So good evening, everybody. My name is Rahul Himrajani, and I am the Faculty Director for the JSW Centre for the Future of Law. The JSW Centre for the Future of Law is a centre at NLS which works to expand academic learning, advance research, and inform policy debates on issues related to law, technology, and system reform. As part of the centre's activities, we organize this series of workshops, which we call the Future of Law workshops, that invite leading scholars to share works in progress on one of the center's thematic areas and receive feedback from peers. Today, we're really privileged to have Bhavin Patel, who will be presenting his paper on Can Technology Augment Order Writing Capacity at Regulators. Bhavin is a program director at TrustBridge. His interests lie in studying regulatory and administrative state, financial markets, and electricity regulation. He also has an interest in applying emerging technologies to legal and economics research and exploring how these technologies could be used to help improve regulatory governance. Bhavin has over 20 years experience across legal, education, and technology sectors, and he's also an alumnus of NLSIU. So welcome, Bhavin, and thank you for doing this. We also have Kashish Makkar, who is also an alum of NLS and who's a regulatory lawyer in UK and India, and also a faculty at Jindal Global Law School. So the way that we're going to do this is we're going to ask Bhavin to present for around 20 to 25 minutes. Then we'll pass it on to Kashish for his discussion comments for around 10 to 15 minutes, and then we'll open it up for Q&A. So with that, I'll hand it over to Bhavin. One second. I think Bhavin, you were relegated to you were relegated to attendee again. Okay, so yeah, I hopefully you can see. Yeah, great.
Yeah, you should be able to. All right, great. I'm going to quickly share my presentation, Rahul, and I'll just request you to confirm that it's visible.
Sure. Yes, it is visible.
All right, great. Thank you. Good afternoon, everyone. Thank you, first of all, to the JSW Centre for the Future of Law for inviting me to present this paper that I've co-authored with a few of my colleagues at TrustBridge and with colleagues at a partner organization called Dono Consulting. I think a couple of them are in the participants list today, so I'll invite them to step in wherever my responses or presentation aren't accurate, as I'm sure they won't be. Thank you, Kashish. I was speaking with Kashish a little before we started and apologizing for making him go through such a lengthy and complicated paper. But if the pre-presentation conversation is any indicator, then Kashish's comments will be very informative and illuminating for us. And thank you, of course, to the NLSIU community. It's lovely to be back. I'm going to jump in and give you a little bit of background about a few things that are not in the paper, about how we led up to the paper, give you a quick summary of some of the main ideas and takeaways from the working paper, and then demonstrate how we've tried to implement some of the ideas and suggestions that we talk about in the paper. So let me start by offering up a question for everyone's consideration. Why should we at all be thinking about good order writing at regulators? I think it's fairly obvious to anybody who's been studying the regulatory state that regulators' actions have outsized impacts on regulated entities. Their orders can pose existential risks for them. This is perhaps intuitively obvious even to somebody who's not deeply connected with the sector. But it's also important to consider a couple of things. One is, let's consider the scale of the potential problem. There's no exact definition for what qualifies as a regulator, but by many approximations, there are at least dozens in India today across the central government and the state government levels. Again, there are no fixed numbers, but some approximations tell us that well over 60 to 65% of the economy is in some form of direct supervision or control by one regulator or the other. That's some sense of how big the questions are that we're talking about. And there's also a qualitative side to this that should alert us to the necessity of studying this, which is many Indian regulators, particularly economic regulators you consider the SEBI, for example, have a concentration of powers. This goes against our traditional notions of the separation of powers. And the quasi-judicial power is one that is exercised in regulators very often by bureaucrats for whom there is no requirement of having any sort of legal expertise, leave alone judicial training. This may vary from one institution to the other, but the example that I took, SEBI, has no such requirement. And so therefore, there are concerns about how these orders are written. There are concerns for at least four sets of stakeholders that you see listed on your screen. The parties directly impacted, but the regulator itself, to ensure that there is credibility in its actions. There are rule of law concerns for the predictability and certainty of the law. Appellate fora are invested in this, and the market and the general public have an interest in ensuring that regulatory orders are also well written. Now, this paper comes on the back of about 2 to 3 years work that we've done looking at regulators in various sectors. And this is an indicative listing of some of the work that we've done, but this should give you an idea of the sort of perspective that we're coming from. So we've looked at appellate orders from ERCs to the APTEL and how they've performed there. We've also tried to collect a data set of SEBI's insider trading enforcement actions over a 15-year period, studied those orders, studied how those orders went up in appeal to the SAT, how they performed there. We've also turned the lens on tribunals themselves. So we're not taking it as a given that the appellate fora are infallible and that they're always right. And so we've collected their orders as well. And we've also tried to see how powers of sanction are exercised by these quasi-judicial authorities. And in all of this, we've ended up studying a few hundred, if not some thousand regulatory orders. We used a combination of methods for this, but typically they would involve some mix of LLMs with human verification. We invest a lot of energy in the verification, and we've seen how these technologies have evolved over time. But one of the things that came out of this entire exercise was to say, all right, we now have a good sense of what a regulatory order should look like. And the should look like comes from at least two sets of concerns. One set of concern is what happens at the level of the regulator itself. What are some basic rule of law requirements that a regulatory order should fulfill? What are some basic principles of natural justice requirements? And what are the requirements of the applicable statute or the applicable regulation in the context of the violation that's being discussed in that order? That forms one set of concerns. The other thing is what happens when these orders go up in appeal? How do we write better orders in the sense that they are able to withstand appeal? And once again, without conceding that appellate fora are always right, having certainty at the initial stage, having predictability at the initial stage is crucial for market participants, for decisions around investability and so on. But our work shows that for most of the regulators we've studied, whether it is some state ERCs or the SEBI, performance in appeal is virtually a coin toss. Most regulatory orders or most regulators will have a performance ratio of about 50% in appeal, which means that half of the orders that go up in appeal will be sent back in remand, or the appeal will be partly or fully allowed. Now, this is an unhappy situation. And so we say, all right, now that we know why these orders are being turned aside, and now that we know what the current gaps are, can we develop a theory of what a good regulatory order looks like? So we attempted to do that. We had a working paper out last year, which articulated this theory based on a survey of available literature and a study of regulatory practices at several jurisdictions across the world. And using these, we created about 70 indicators specifically for insider trading violations or orders that discussed insider trading violations. And I'm going to quickly show you what that list looks like. So this list has a number of different sections. Some, as I said, relate to basic rule of law requirements. Some relate to principles of natural justice. including, for example, harder to discern indicators such as is there reasoning provided or not. Some are contextual to the kind of violation that's being discussed. And each of these carries a different weight, which you see in this column E. So some of these, it could be argued, are less important than others. Having a clear order title is a good thing, but arguably it's not as important as providing strong reasoning. And so we hope that the weights adjust for that to some extent. And so having done this, we said, all right, there are a few open questions that are still left that we don't know enough about. We continue to work on those, such as, for example, the concern around application of mind. This is a common ground of judicial review of regulatory orders, but it is unclear what exactly counts for application of mind. And why we're interested in this problem is, and I'll just give you a clue to that, is if you are to use technology, particularly generative AI technologies, in the order writing process, then is there a concern that there is a non-application of mind by the human adjudicator? We need to have a clear response to that question, and that's what we're trying to figure out. We also argue that regulatory orders should be consistent, but it is one thing to say that orders should be consistent and another to say that there should be something like a theory of precedence for Indian regulators, which does not seem clearly articulated at the moment. And so that's another question that we're looking into. But at the stage of this paper, we're asking a few specific questions based on what we have understood of quasi-judicial functioning at Indian statutory regulatory authorities. So I'm using the term SRAs from here on to distinguish institutions that embody regulatory functions and activities, but are distinct from similar functions being performed in, let's say, an administrative department of a ministry. So we're looking at more or less standalone, somewhat insulated institutions. SEBI comes to mind, RBI comes to mind. So we ask, if we can use technology of this sort at scale to try and understand what's wrong with orders, can we turn that lens around and ask if technology can be used to improve how order writing is done at SRAs? And so the four specific questions we ask are, if you are to use this technology, what sort of problems might this raise? There is some discussion on this, or rather there is a large amount of discussion on this particular question in the public space already. Less so on the second question, which is, what are the specific administrative law problems that this might raise? Have other countries adopted this technology? And if they have, what guardrails have they adopted? And can we put all of this together to propose a framework that could help avoid these problems when you use LLMs in quasi-judicial settings in India? And so we suggest that the paper makes a few contributions. I will focus here on just one or two, just to underscore some things that I said in the previous slide and one new thing. There is a large amount of discussion, as I said, on issues such as hallucinations, on issues such as inexplicability of these systems, of their statistical and unpredictable nature. That is all well taken, but we must also ask the question, what are the specific problems of administrative law that we must address if we are to consider using these technologies in these settings? So these problems that manifest in the use of LLMs, how do they relate to administrative law problems? What is the standard we must satisfy in order to overcome these problems? That is one. The second arises from the idea that saying anything about technology is a little dangerous, because particularly with these sorts of technologies, this paper was written last year. I was blushing as I read it again yesterday in preparation for this talk, because so much of what we're talking about is already out of date. But that's not central to the argument here. What's we think central is the problem solution evaluation framework that we propose. And so we think that regardless of what the state of the art of the technology might be, it is useful to adopt this sort of framework in considering the use of technologies in these settings. And that is something that we'd like to draw your attention to. We also suggest that it is useful to drop a singular emotive lens when one thinks about order writing. And by that, I mean, the reaction one gets when talks about the use of technology in order writing is that it will replace human decision making. That's not the argument. And it's also important to remember that there are several steps in the order writing process, of which decision making is one part. Some simple examples of that: at one end is research, at the other end is the review of a draft. And the decision making is something that is perhaps spread across these steps. Different technologies could be used to assist these activities. Perhaps in some of these steps, we don't want to suggest the use of any kind of technology. And this is the sort of nuanced approach and argumentation that we would encourage for any discussion in this area. But just to pick up on the last point, it's not necessary that an LLM or a generative AI application is always the best answer. There are many older, more deterministic, more predictable technological methods that can and should be used where possible. These are easier to monitor, these are easier to supervise, and these are easier to control. And so therefore, we suggest that a combination of these methods should be used. So where in all of this is the need for LLMs, and why should we think about those? I highlighted earlier problems such as the lack of a good theory of precedent. This is also something that's linked to the reality that there are very few good, reliable databases of past orders that are well indexed and that are searchable along themes rather than just keywords, particularly within regulatory institutions. This is an area that LLMs perhaps might help with. And we've put up 4 sets of requirements on these slides. This typology is described in the previous working paper that I described, and we suggest that in each of these areas, there are some contributions that LLMs might be able to make. And I'd be happy to share the slideshow afterwards with Rahul for onward circulation. We also acknowledge that there is the beginnings of what one might think of as an emerging theory of how these technologies may be used in governance in India. There's a variety of policy statements, governance frameworks, so on. No hard law just yet, but all of these put together could give us an indication of where that might go. We've also looked, as I said, at frameworks in other jurisdictions. And when we combine what we see in these Indian statements and the statements in other jurisdictions, we come up with a set of design principles. And so now we do the integrative work, which is to say, we said that there is a set of concerns about the nature of these technologies. What are the specific problems that these might raise? And so we've tried to come up with a set of 6 types of such problems. What are the consequences and what are the administrative law concerns that might be impinged upon by these? 4 of these will have some admin law principles identified. The last 2 may not necessarily be an admin law concern, but it is something that we are alive to and concerned about when we propose the use of technologies in these settings. And so we say, all right, if these are the problems, these are the design principles that we've learned, let's take the next step and suggest a set of solutions. And by the use of the word solutions, we don't mean something that makes the problem go away. If I knew how to make hallucinations go away from LLMs, I would be a much richer person and not delivering this talk. But what we do suggest is that a solution can help you identify where the problem is so you can go in and fix it, or at least to some extent, reduce the extent of the problem. The third step that is necessary is to ask, is that solution working at all? And so do we have an evaluation scheme for that? And this is what we suggest that framework might look like. So here are a set of problems. Here are some solutions derived again from the design principles that we've seen in governing documents from across jurisdictions. And what are the kinds of solutions, evaluations that we can come up with to see if these work at all or not. And once again, this is fairly detailed, but perhaps we'll just take one example. The most common example that comes up is hallucinations. So yes, hallucinations are a problem. Why are they a problem in law? It might raise concerns of non-application of mind, no clear reasons, or at the heart of it, arbitrariness. Are there some kinds of technological and design and implementation solutions that we can come up with? And then how do you evaluate whether or not these are working? And we fleshed these out for each of the 6 sets of problems that you see described here. I'll just leave this on for a moment, and I'll repeat the caveat that I'd made at the a few minutes ago, which is that some of these technological solutions may seem a little out of date. But having said this, we would like to suggest that we must always think of these technologies as augmenting human capacity rather than replacing human decision-making. The core decision-making process cannot be outsourced, and so we should think of these as review and research systems rather than drafting systems. And the framework is one way of thinking about this. We've also made a set of stage-wise recommendations for how institutions can think about adopting these technologies, divided into the build and the use phases. The build use is prefatory to the actual implementation in decision-making. And finally, forgive the slightly cheesy acronym that we've come up with, but as I said, we've tried to come up with some proof of the pudding, as it were. Are we simply talking about these solutions, or can we try and build something that shows that these solutions and evaluations might work? We have a very, very early version of this tool that I'd like to show you now that we finished just over a month ago, and we're hoping to develop a more fleshed out version of this by the end of the year. So this is what the tool looks like at the moment. We have scrapers that are pulling in orders from regulators' websites. For the moment, we're working with a small data set of SEBI orders and corresponding appeals in SAT. In the full version, we hope to have more regulatory orders updated on a daily or if not more frequent basis. The order comes into the tool, it goes through 3 sets of evaluations, and then we generate a report for each order. This has what you might consider some of the material facts, the main allegations, what the findings are, what the sanctions imposed were, what are the codified law in the form of statutes or regulations, as well as previous decisions that have been cited by the adjudicator in the order and not in the arguments of parties. I showed you those GOW metrics, good order writing metrics, a little while earlier. The tool is now evaluating each order against each of those metrics. A 1 indicates it's present, a 0 indicates it's not, a 99 indicates that it's inapplicable. You get an overall score at the end for completeness, but more than that, I would suggest, imagine a situation where a regulator or a regulatory official is able to upload a draft order onto the system and gets this sort of health check on that draft, and is then able to go in and plug the gaps, as it were. And finally, we have a section called Related Regulatory Materials, which has SEBI and SAT orders with similar material facts and a discussion on similar laws that is involved. And that is something that we suggest the person drafting the order should look at before coming at a final decision. And this has, as I said, some of the solutions and evaluations we've talked about, but a fuller version of this should hopefully be ready by the end of the year. I think I'm at just about 20 minutes and I'm going to stop now. Thank you so much.
Thanks a lot, Bhavin. That was some fascinating stuff. And I think there's lots to discuss. But before we open it up for Q&A, Kashish, please go ahead.
Thank you so much, Rahul. Just confirming if I'm audible.
Yes,
Great.
yes, Kashish.
Great. Thank you so much, Bhavin, for this wonderful presentation. I mean, really, really fascinating stuff, as Rahul said. And I didn't know about the tool that has been developed by TrustBridge, and I certainly can see it being really, really useful. Before we go into like me asking a couple of doubts about the tool itself, I'll share what I had prepared on the basis of reading the paper and my thoughts around it. And then we can sort of probably have like a couple of minutes of non-structured discussion at the end. But yeah, I'll just share my screen at this point now. Great. So in terms of the paper, right? The problem statement in the
Kashish,
paper.
if you're sharing something, it's not visible.
Okay. Just
It
a
was
sec.
visible for a bit, and then I think it stopped.
Just a second. Technology might or might not augment the order writing. It needs to augment my use of these systems. Just give me a second. So currently you can see,
Yeah, I can see it now.
and can you tell me what is it that you can see? If you can see the slideshow or you can see the full window.
I can see the full interface as well, yeah.
And now it goes away.
Now it goes away. I think, yeah, there's some problem with this thing.
Yeah, okay, then probably people will have to bear with looking at the full window.
Sure.
So I'll just begin so that we avoid wasting more time on this. Yes, so again, thank you so much, Bhavin and the team for leading like amazing piece of work on this front. I think really, really needed, especially given the problem statement, which is the regulatory orders have a substantial impact on individuals, on the economy as such, in terms of the kind, like considering subjects that they cover, such as electricity, competition law, securities, and the kind of impact they have had in terms of how the economy advances and the confidence it reposes in, for example, the institutions we have, or for example, in terms of people trying to build products or businesses in India. So clearly, like regulation plays a substantial like role in our economy. And when we see orders, for example, the ones that are cited in the paper, which can really shake the foundations that the regulator is supposed to preserve and guard and sort of uh, hold together for the benefit of the society. And when you see inconsistent orders such as standard of proofs being applied differently across different orders, those sort of make your confidence go away in why these institutions were set up and for the purposes they were set up. And apart from being making your confidence question in the institutions itself, they also have other costs, which is the point 3 on the slide, which is a lot of the orders can be erroneous in first instance, and that leaves a lot of scope for then appeals and then going all the way up to the Supreme Court. I practiced competition law in India, and I remember taking the competition commission itself, not like while the orders, etc., and the investigations that may be conducted seriously, but in terms of the final decision being okay, it has been passed, but we don't need to worry about it today. We have 10 more years and we will get stays at different levels against it. And that's been sort of a reality in terms of regulatory decision making, in that a regulator can take a decision today. And I think if I recall from my experience at that point, I think most cartel investigations that happened in Competition Commission at one point are sort of at some stage still pending before the Supreme Court. This could be the famous ones, which are, or for example, in the abuse of dominance cases as well. I think we haven't had a substantial decision in the past 10 years that has happened, which the Competition Commission of India decided and then has still stuck uh, in terms of jurisprudence, and that has defined Indian competition law because the Supreme Court has held a stay. So, I mean, just for interest of listeners, if people want to know, there was a 2012 decision that the Competition Commission of India passed around the abuse of dominance by original equipment manufacturers of car companies, which was passed in Shamsher Kataria. And I think the stay on that has been more than 7 years at this point, which was passed to the order was to the effect that the companies which are, for example, your Maruti Suzuki, Honda, Toyota, etc., they have abusive conditions in their after sale service contracts when they sell a car, which is you can only get your car serviced at their um, locations. Otherwise you will void your warranty, etc. And that was just a competition law decision that was passed in 2012, and we are still yet to see the light of the day in where the jurisprudence on that stands, whether that actually amounts to abuse of dominance or not, because Competition Commission of India's decision is still went through Compat, went to Supreme Court, and it's still somewhere there. So the point that I'm trying to draw is an improper regulatory order, irrespective of the fact that uh, it may be inconsistent. It can also produce a lot of costs in terms of the appeals and leaving the uncertainty behind what the particular area of law stands for, and therefore we need to think about how we can make them foolproof in the first place instead of waiting for an appeal to decide over a course of 10 to 15 years. The fourth point why focusing on this problem is important, as Bhavin highlighted, is we need to take away the arbitrariness, and irrespective of what we may like or not like, there is a reality which is that regulators do not are not resourced well or are not functioning well due to a number of reasons that may be in practice applicable to them, and are not really applying their mind to how different cases should be decided in a particular consistent manner, and some cases get a particular treatment while others do not, and that's sort of at the core of arbitrariness, and technology can be a real solution there by, for example, the tool that Bhavin highlighted. If, for example, the TOT tool can show me similar cases in which similar issues arose and how in the past those have been decided, and I could make consistent decision making happen. Those are not happening in the current situation, and that is a real issue as well, and gives you a sort of, again, the flavor of improper foundations and shakes your confidence in the system. And then with a related point is non-application of mind. But I think the problem statement has been well laid down by Bhavin, so I'll not go into more than that. And again, this next step, the next part that Bhavin highlighted has already been well discussed as well, which is and has been covered in what I was trying to say in the previous problem statement slide, was that to have good regulation, you need to demonstrate application of mind. Your decision should have reasons. Your decision should not be arbitrary. Your decision should be impartial and unbiased. And obviously, to demonstrate all of those conditions, your decision should be transparent in the first place. So to have the idea of regulation really serving the purposes it is supposed to serve, the Competition Act, for example, suppose effectively preserving competition, or securities regulation effectively having a good market condition for trading of securities, needs to demonstrate all of these requirements before it can actually solve the problem of uh, providing a like providing a good infrastructure for why they have been actually set up. Now, this is sort of the sphere in which, or the framework in which we exist today. There are these problems, and we require these elements for good regulation. And I borrowed this table from Bhavin's paper. I really liked it. So potentially LLMs can help us, but they present a number of problems for us. And those problems, while those problems can, for example, give us some relief in a way in terms of thinking about the fact that at least when for example someone is thinking about a regulatory problem and then thinking about how technology might help, those technological tools might give us some relief against the problems, but they present certain new problems in themselves, which is, for example, if you are to think of the fact that there are inconsistent orders currently in place, and technology can help us go back to look at different tools, for example, the TOT tool that was showcased. The bigger issue that can potentially arise in using those technological tools is if you were to steadily hand over the whole decision making to an LLM, it can potentially produce a situation of it has no awareness of its own limitations. So, for example, if you are to upload 10 orders on a particular fact situation to an LLM, and you're given it a new fact situation, the LLM will never tell you that this fact situation is beyond the 10 orders that you have uploaded for its decision making. It will try and come up with a solution within those 10 decisions that you have uploaded, which is the Dunning-Kruger effect. It does not know its own limitations. So while you will be in and I understand we might have reached a situation where we are able to overcome those limitations in technology, but still, the idea being we have certain problems, we need a solution to those problems. LLMs can potentially present a solution to those problems, but they themselves in providing a solution present certain different kinds of problems. And Bhavin's paper does a really good job in highlighting how those problems can perhaps be resolved. And that is sort of the most interesting part in terms of the contribution that the paper makes to our thinking, which is it talks about how you can potentially solve. So just so far as so that I've not lost my audience, I will clarify in what terms of how I've approached the paper. The first bit is there are problems that are existing in regulation as of date. There are certain on the foundation level, there are certain problems that exist. On a foundation level, there are certain requirements through which good regulation can happen. We need to resolve the problems that exist, and we are thinking of technology as a tool for solving those problems. But to use technology as a tool to solve those problems, we need to ensure that the technology complies with the foundational principles of having good regulation. So the paper proposes certain solutions to be used for solving those problems that technology will face in solving the problem statement that we are facing, which is inconsistent orders or issues with regulation, etc. And those are segregated into two phases. In Bhavin's paper, one is how you integrate technology in the building phase for these for the regulators, and how the regulators actually use the technology in practice. And the paper has already, I'm sorry for the numbering mess up that has happened, which is shows 111 on all of this. But the idea being these are equally important tools to be incorporated when actually being used by a regulator in their practice when someone is actually using technology to solve the problems with inconsistent regulation. Now, again, Bhavin has already gone into the problem solution evaluation framework and how LLMs can be used in an effective manner to solve the problems that we are facing with regulation. So I'll not go into more detail in that. But my sort of comments on the paper will be around the fact that while the paper presents sort of takes a framework of talking about how one can incorporate technology to solve the problems that we are facing in current regulation, it approaches the problem through that framework in terms of how we can solve the problems that we are facing through technology, and perhaps the solutions and perhaps the problems that the technology itself presents can be solved in solving the problems. So it takes that approach. I think one of the more fundamental contributions that the paper actually makes is to get us prepared to think about what are the upgrades required in the first place before we think about or before we see that the technology can effectively be deployed. And the upgrades required, in my head, are three and can be classified under three categories. So one is the legal frameworks that may be required to effectively integrate LLMs or, for example, technology to solve the current regulatory problems. Second is the upgrade required around human resources. And third is the upgrades required around institutions that we have for regulation in itself. Uh, so I'll begin with the first one, which is the upgrades required to legal frameworks in the first place to have sort of the
Kashish, sorry to
technology.
interrupt,
Yeah,
but we're sort of running out of time. So if you could
okay.
sort of
Yeah, I'll
summarize
summarize.
in around 2 minutes. Yeah, thanks.
Yes, I'll summarize this in quickly. But the idea being, to integrate technology, you will need upgrades to legal frameworks in terms of currently in India, you only have a right to information. But I think the information infrastructure exists across a spectrum, and India currently only has a right to information infrastructure, but it needs to move from right to information from a right from a right to information infrastructure to a right to be informed infrastructure, which is state takes proactive measures to tell about how it is using particular tools in its decision making stack, in its policies. And for example, for example, this right to be informed is sort of existing in the RTI Act in itself under Section 4 of the RTI Act, but it is a very North Star statement in which the way it exists. The Supreme Court has tried to make advances on this front through its jurisprudence, but it has not percolated in policy as of yet. So to implement technology to solve the problems that we are facing today, you have to sort of upgrade your infrastructure to make it a right to be informed infrastructure in terms of you cannot have people applying to obtain information. Instead, the state should have a proactive disclosure system. Second, you need a lot of changes to human resources that you have today who are manning the regulatory systems. So, for example, if we are facing issues with respect to people who are at the helm of regulation currently not taking proper decisions or making decisions which are inconsistent, etc., you need to do a lot of training for them to now not only take consistent decisions that the technology is showing, but also upgrade them to, for example, do proper prompting, evaluate the solutions that have been proposed, and then also sort of ask the questions, where are the issues arising? If those people are not able to take consistent decisions in accordance with the precedents that are already provided, will they be able to actually use technology in a consistent manner to produce the outcomes you are desiring? And finally, perhaps there is a situation that you need to recruit a technology vendor in the first place to design certain specific tools for a particular regulation, who can also monitor alerts when things have gone wrong, and then can also recommend, like for example, the people at the helm of regulation in those institutions, if they are, for example, highlighting concerns, they can also monitor the alerts that have been given and make improvements. And finally, at the institutional level, you will need a lot of changes to the data security stack in itself that the regulators have, because they do deal with a lot of sensitive information, and they will also need to improve their data management system. Rahul, if I can take 1 more minute, and then
Yeah, sure.
and I will close it. Yes. I think one interesting bit when we think about using technology for solving the problems that we have highlighted is why why do we do it, right? So why should we go ahead with this? Because clearly the task at hand is not going to be easy. Like Bhavin has highlighted, the technology presents a monumental challenge, both in terms of developing frameworks for use of technology. And like I have highlighted, it involves a lot of upgrades required to legal frameworks. It requires a lot of upgrades required to human resources. So why do it, right? We need to do it because there is an issue which is it is currently leading to. So if you were to look at 3 centuries ago, people would think of why have a company in the first place, right? So there was a situation where people would set up businesses together in partnerships, and when one or the other person would be at the end of their own life, the other person's incentives might not align with it, and then the business itself. So for example, if Bhavin and I were to today start a business and I am towards the end of my life, Bhavin might try to corner the whole business. And at that point, people decided that the best solution to this is to create businesses through an artificial legal entity where you separate ownership from management. The businesses can continue for generations, and the people who are actually owning or have invested in the business, their incentives will not sort of diverge due to people's lives ending. Now, that concept today sounds very basic in the concept of a company, but at one point it might have been really revolutionary in terms of people who are actually owning a business might not have nothing to do with the running of the business, right? So perhaps, and that sort of foundational concept of separating ownership and management has become the foundation for engine of growth over the past 3 centuries. Like having a company is such a foundational concept to the economic growth that we have had. We cannot imagine our economies without it. Now, if we are to think of why we need this in regulation, perhaps due to the same reasons. Perhaps we are at a stage where reasoning needs to be separated from decision making. The reasoning can be done better by machines, and the decision making can be done better by human beings, which is sort of what the framework the Bhavin's paper presents. And it might seem like a revolutionary idea today, but it might be sort of the solution that can actually take us out of the problems of the world that we are seeing today, of inconsistent decision making, of errors, and of like resource use that is inefficient in terms of 15 years of pending appeals before the Supreme Court, etc. Now, that is the reason why we might need to do it. And one final point, and then I will close it, is we should also still be clear that while we are doing it, we do it not for the purposes of the goals that are being articulated in the tech ecosystem, that through this use of tech, we will be able to achieve a legal singularity, which is there will be a situation where there will be no need for actual an adversarial decision-making procedure or parties to be debating points of laws or points of facts. That is sort of not the reason why we do it. We do it for efficiencies. We do it for better and improved decision making, and we remain aware to the costs and benefits of the technologies that we are introducing to make these changes. And in that, we go back to what Bhavin said, that a lot of the problems in regulatory decision making might not even have to do with the orders in itself, but through the process that has come in. So if you are thinking too much in terms of the benefits this technology might bring, you need to be anticipating the costs, like the costs and the benefits that you need to basically be true to yourself in terms of what is it that you are solving and the benefits you will derive out of it. And I see that I've reached my time, but I can go into this at a later point through for like casual discussion with the audience, or if Bhavin has to say anything.
Yeah, great. Thanks a lot, Kashish, for those insightful comments. So I'll hand it over to Bhavin to respond if he wants, but I'll add a couple of sort of points of my own, which are sort of tangential while people sort of think of questions. So if you have a question, we'll open it up for Q&A. We have a little bit of time for that. You can use either the Q&A tool which is on the top, which should be on the top of your dashboard, or you can use the chat, or you can raise your hand and we'll allow you mic access and you can ask your question, right? So while you think of questions, a couple of questions from me, Bhavan, because I have seen this paper at different stages and I see the tool now. So I think now I'm much more excited about sort of deployability and the possibility of actually using this for some legal system transformation. And and a couple of speculative questions I had for you in that respect is one on contextualization and where is this tool or is this sort of framework context specific, right? Because the problems of bad order writing are not, as you know, not just a problem of regulators and tribunals, right? And it is a far, far worse problem in the district courts and in the basic court system in India, right? So while the regulatory regime allows you some sort of at least statutory and some sort of structure through which you can sort of pass these kinds of frameworks, the rest of the law is much more loose, for lack of a better term. So do you see that that this tool can be used beyond the sort of beyond what you've suggested here? And secondly, I think it's important now, again, once I've seen the tool, to ask about the deployment question. I know this question has come to you often and you've tried to do this, but I think deployment, along with sort of something that Kashish mentioned, which is infrastructure constraints, becomes a becomes quite a challenge for legal transformation and legal system reform in India, right? And we've tried multiple times to ask the court to use far simpler tools with ideas of efficiency, which don't have the characteristic flaws that LLMs might have, and we have largely failed. One, because of change and behavioral sort of inertia, and the other because people don't have internet, people don't have computers, people don't have papers. So where is this? Where are you talking about LLM? So maybe sort of along with responding to Kashish's comments, if you could answer these two questions as well.
Brilliant. Thank you so much. Thanks, Kashish. Thanks, Rahul. These are great questions and suggestions, and I'll try and go through them in the sequence that they came out. So I think the first set of things to respond to is, Kashish, you're absolutely right. No proposal by itself, certainly not a technological proposal by itself, can bring about the sort of change that we would like to hope in the system. There is a need for larger environmental changes. You call these upgrades. I think that's a fairly accurate description of the trajectory that these changes must follow. But yes, there are human elements, there are organizational elements, and there are a number of things that will have to come together for this sort of change to come about. I'll add to the set of suggestions you had one more concern. As part of the legal framework, perhaps there are systemic questions about information and what degree of information we should expect to be able to receive. I would also suggest that there are, on occasion, problems of fairly vague language in regulation that will defeat most attempts, no matter how well-intentioned, to try and arrive at more predictable, more consistent solutions. And so thank you for pointing those out, very keenly aware of those. This relates somewhat to Rahul's comments as well. But yes, these are things that one certainly needs to think about. One of the ways in which we're attempting to do this is to have somewhat smaller versions of the talk that we just had with practitioners, with regulatory officials, with anybody really who we can find who will bear with us for about half an hour and listen to us talk about regulatory orders, to try and build a more contextual awareness of these institutions, the people in these institutions, and the organizational practices. So we can think of how these systems might actually come into use. I think the suggestion or the analogy of how ownership and management were first separated in joint stock companies, which seemed a shocking idea at the time, is an interesting one to draw with reasoning and decision making. And I think the one bit from there that I would like to pick out and emphasize is something that we'd alluded to earlier, but decision making is perhaps one part of a much larger process, which is order writing. And so therefore, we must not be carried away by thinking that decision making is all that's involved in order writing. There are several prefatory and succeeding steps, and we should try and separate those out and think about those. Moving on to Rahul's comments. So when I showed the set of indicators, I'd suggested that some of these are cross-cutting because they reflect or they speak to concerns of rule of law or principles of natural justice, and so in that sense might apply across a variety of fora. Some are specific to the violation. So the most immediate response to the contextualization question is those indicators that speak to the specific law, of course, need to be amended and changed depending on who you're going to. Whether you can go from this to a court, in theory, it should be possible, but we pointed to two problems of theory that we are yet to solve or to get an understanding of, which is application of mind and precedence. Anyone who's engaged with administrative law principles would also appreciate that there's as many answers depending on how many people you ask. What is the difference between a quasi-judicial and a judicial process? And so I would hesitate to say that this can walk across to a court as is, but one can imagine many potential uses for a tool like this. Let me offer up one, which is to say that we know that in India, there is a practice of the government appealing any adverse order passed against it. And this happens sometimes for concerns that there might be bodies such as like the CVC or the CBI, which might be, which one worries might conduct investigation if one is seen to let go of appellate orders. But if a tool like this can tell you how an order is likely to perform in appeal, might it be a good way to take more rational decisions about a litigation strategy and how the government should and should not appeal orders? So I think with a little bit of imagination and a lot of hard work to contextualize, there are many potential uses. Can this go to courts? I think we're beginning to see experiments such as Pukar, where in the Kerala district courts, at least many parts of the workflow are being digitized. And so we have some new ideas emerging from there, which offer us hope and encouragement. The infrastructure constraints are real. They are important to think about. And in this context, I should say something that I should have said earlier, but let me also put it out there that given the nature of how we are set up, TrustBridge is a Section 8 company. We are a not-for-profit. We're interested in improving the rule of law for better economic outcomes generally. We propose to release this tool as a public good once it is developed. So this would be accessible for no charge to anybody who wants to use it. Of course, that version of the tool will only have published orders. And so a court official or a regulatory official should not be uploading draft orders on a public tool, certainly. We understand that there are problems of lack of internets and computers, but we are a country that leapfrogged that problem and became amongst the largest population using the internet through mobile phones. And so therefore, I would suggest that there is some room to think about solutions on that front as well. But if nothing else, even if this is something that we cannot deploy within an institution, we hope that forward-thinking regulatory officials who are concerned about orders that they're writing will at least use a public version. And that we think might help nudge the quality of orders a little forward as well. So I'll pause there again and see if there are any more questions from the audience.
So we have very little time, but we have some time for questions. And Kashish wants to respond as well. But Kashish, let me just see if there are any more questions. But actually, go ahead. Actually, tell people if people have questions, please raise your hands. Or so Mr. Anant has questions. So, but Kashish, go ahead, and I'll give Mr. Anant mic access to them.
Yeah, I just wanted to flag the bit that Bhavin said about using these tools in terms of what a regulator might think of in what government, for example, might think of in appealing a regulator's decision, etc. I think that's what that was going to be one of my final points in responding to Bhavin's paper, which is when we look at these tools, we should also look at keenly about the costs and benefits. Perhaps a lot of the reasons why, for example, a lot of these regulatory problems exist so we should also be perhaps at a slightly on the slightly cautious end of our optimism with the technology as well, because while the technology exists in terms of taking us forward there, we might need to understand that a lot of these appeals, etc., that happen at the government's end might not really have anything to do with the reasoning in itself, but just the fact that they can appeal and they want to delay a particular decision. So, for example, England is a good example of how they have been able to curb appeals simply through the fact of keeping the grounds very limited, making sure the costs are put on parties who actually appeal, and then the costs are really proportionate to appeal in the first place as well. So a lot of these infrastructural changes on that side are also really, like, we should be conscious of saying that the technology might be able to solve this. It can be a great tool there. And I agree, Bhavin is also there. It's just I wanted to flag that when we see these tools, we need to see what is it that they're actually going to solve, and then proportionately map the benefits that can come out of it. But yeah, I allow Anant, I think, to come in. Who is his
Yeah,
hand
Anant,
raised?
please go ahead. I think you have mic access, so please.
Yes, I hope I'm audible.
Yes, you are. Go ahead.
Yes, so this is more of a public-facing sort of a question, and more related to, since you mentioned you had conversations with practitioners and regulators about this. But since there's a lot of tech illiteracy in India, and a lot of these LLMs, especially LLM with AIs, end up being black boxes that people don't recognize or understand how they work. Is there a possibility of a lack of trust or a loss of trust in these in the regulatory bodies if sort of LLMs become more prevalent in making in the reasonings or decision makings you in made by these regulatory bodies?
Uh, Great question, Anant. And in fact, the black box problem is one of the six problems that we spend some time talking about in the paper. But I suspect you're coming at this from a slightly different angle, which is there a potential lack of trust among the public if regulatory institutions are seen to be using inexplicable machines to come to answers rather than applying their own mind? This is a real and valid concern, absolutely. And so we do not propose that you take the human out of the equation and replace it with Claude Cowork. We suggest instead that, for example, a workflow that could be accommodated is to say that a human writes a draft, a machine reviews the draft and makes 5 suggestions for changes, and the human must explain why they agree or disagree with those changes. A workflow like that could be seen to do 2 things. The first is to tremendously augment the capacity of a singular decision maker. And secondly, to in fact nudge the human decision maker to reason, to apply their mind, where for some combination of reasons they might not have done otherwise. And so that's the sort of application we would encourage. We certainly do not propose that any sort of decision-making authority, any sort of governmental body should use these machines exclusively without human supervision or human reasoning.
Yeah, Bhavin, we have one more sort of related question. Maybe this is the last one we'll take because we're out of time. They say, Mr. Swarnim Srivastava says, Sir, given the case law in India, the proposed framework relies heavily on edit rate and other metrics to make sure there is application of mind in the fold. But how do we tackle the automation bias? There is a possibility that people rely on these more than they trust themselves.
And I think this is this follows closely on the heels of the previous question, and it is somewhat related. Let me say that the danger is real. As someone who has been using these systems for a few years, increasingly in the recent past, as the systems have gotten better, there is a certain seductive appeal to outsourcing all your work to these systems and not working yourself. This problem is well contextualized against the backdrop of tremendous caseload in India. We do not assume to have solutions for the caseload pendency problem in courts. There are many, many scholars as well as others working on this problem, and we'd like to contribute towards that. But as Kashish pointed out earlier, and our sense also is that, at least as far as some regulators are concerned, staffing is not as big an issue as it might be in other institutions. Caseload may not be as big an issue as it is in other institutions. But it is important that we constrain any short-circuiting or bypassing of the human reasoning process. And so I'll take a few seconds to elaborate on some of the solutions that we proposed in the paper. So the solutions that we suggest are not all technological. We also offer some design solutions. These are interface proposals such that a machine should not be able to do the work for you unless you complete certain steps. So for example, you should not be offered off the bat substitute text to replace what you have written in a draft. You should instead be asked to consider a few points and offer your responses for why you agree or disagree. And then perhaps you can revise or recraft that portion of text. That's one way to do this. I will acknowledge, however, that the reality exists that human beings are fallible, that there are problems that could occur. Merely because you augment somebody doesn't take away all the problems that might exist simply by virtue of that person being in that situation by itself. It's not a complete answer, but I hope this helps.
Yeah, thanks a lot, Bhavin. We're out of time. We're at 5:05, so I should close the session. Thank you again, Bhavin, for taking out the time and giving this wonderful presentation. The paper is up, so if any of you would like to read the whole paper, please go ahead. The link is on the website as well, and if you search on Google, you should find the paper as well. Thank you, Kashish, for agreeing to be a discussant and giving your very important comments. Thank you everybody for joining us, and we hope you join next month as well, where we'll come back with another Future of Law workshop. Thank you, everybody.
Thank you.
Thank you,
Bye.
Rahul.